Hello and welcome to today's presentation from ABB Enterprise Software, EPA's Clean Power Plan Update. Today's speaker is Eric Hughes, Vice President of the Advisors Team.
Yes, as I was introduced, my name is Eric Hughes. I'm the Advisors Vice President and actually in charge of the team that does integrated resource planning services and request for proposal analysis type services, those sorts of consulting projects. I've actually been doing this kind of work for about 27 years now, and as a result, I think I've had gone through several iterations of new rules to the Clean Air Act, the latest one, of course, being EPA's Clean Power Plan from last year. What we're going to be actually covering today is a little bit of update on the status of where we are with it right now, but I'm primarily going to be covering the actual arguments of the petitioners to the U.S. Court of Appeals for the District of Columbia Circuit and obviously the respondents, the EPA, the administrator, and what their arguments and counter-arguments are, and kind of give you my take on this. So getting started with my actual presentation, I will, of course, do a slight introduction to this. I will then talk about the court case. I've got a very few slides at the end that utilize information from both our fall North American reference case and from the spring North American reference case results. And then I'll give you my conclusions as to where I think this is all going. Okay, first, a little disclosure. I actually marched in Washington, D.C. on the first Earth Day, April 22nd, 1970. However, at the time, I was a high school student in Arlington County, Virginia, so that was clearly a very long time ago, and I was quite young. I will also now give you the slight disclaimer. I am not a lawyer, nor have I ever played a lawyer on television, in any movie, or on the stage. And the opinions that I will be expressing here are mine alone and do not reflect those of ABB or ABB Enterprise Software in any way. This is my take on how I think this is all going to play out, and opinions I express about the arguments of either the petitioners or the respondents. Again, those are mine alone. That's kind of the way I'm reading these things. So let's get into our little bit of an introduction. Where exactly are we with the CPP right now? Okay, the final rule for reducing carbon pollution, the emissions guidelines for existing stationary sources was actually from the EPA, was printed in the Federal Register back on October 23rd, 2015. There were some court cases that had been started prior to that actual printing in the Federal Register. Those were dismissed by the court as being premature since it had not yet been officially printed in the Federal Register. Since then, multiple states and other parties have sued the EPA to block the implementation of the rule. There were 5 different cases that have been consolidated in the single case that will be heard before the D.C. Court of Appeals. The opening briefs for the petitioners were filed back on February 19th of this year. So the U.S. Court of Appeals for the D.C. Circuit initially denied a stay of the rule pending their decision on the petition. Okay. I'm not getting my next one. There we go. They were initially to hear oral arguments on June 2nd, so they would have already heard it. However, the D.C. Court of Appeals decided that they would, instead of a 3-judge panel hearing the case, hearing the arguments, decided that they would instead hear the arguments en banc. In other words, all of the justices, all of the judges in the D.C. Circuit Court would be hearing this, and they have scheduled this for September 27th. So we are a little bit delayed, although this is anticipated to perhaps accelerate the final decision from the court, because it is always possible that if the 3-judge panel had already heard the arguments on June 2nd, that whatever their decision was or would have been, which we would have not expected for several months, so possibly August, we would have gotten a decision from the court, perhaps even into September. Instead of, at that point, then the petitioners could have, or the respondents, whoever the ruling went against, could have then asked for the entire court to hear it en banc at that point. So this may have actually accelerated things a little bit to have the court decide to hear it en banc initially, even though it delays the first hearing. However, the petitioner's denial of appeal was appealed to the Supreme Court. Supreme Court decides to issue the stay, and of course now we're back in the appeals court and waiting until September to hear what's going to happen. So what's clear in all of this history? It's a mess. Politics and perceptions are what's driving everything here, and we've seen no evidence of any rational discussion of the actual issues between the parties up to this point. One thing we can conclude is that because the Supreme Court justices did issue a stay, that they believe the suit may have merit, or that the final resolution of the suit will necessitate a delay of the rule's implementation. So I think we can expect that regardless of how this all comes out, that there may be a delay, or almost certainly at this point going to be a delay in the implementation of the rules should the decision go forward that the EPA acted within its authority and under the law correctly to issue the rules for the CPP. Regardless of what the D.C. Court's decision is, this ruling is going to be appealed to the Supreme Court. So we can expect that even after the D.C. Court hears the appeals near the end of September, the probability that we will have a decision before Thanksgiving or Christmas is somewhere in that time frame is fairly low, and then the appeal, of course, will go to the Supreme Court, and it will almost undoubtedly not be heard until the court is in session sometime next year. So, but we also now have a potentially split Supreme Court with the death of Justice Scalia. So God only knows what's going to happen there. So let's talk about, for the next few minutes, let's talk about the court case and the arguments. So first, the petitioners, who is petitioning for a stay of the rule. We have 5 suits, as I mentioned before, consolidated under State of West Virginia et al. Versus the U.S. Environmental Protection Agency et al., the et al. Being the administrator. It includes 27 states, and it has 140 other entities that have joined up with them, including power companies, coal and other energy companies, several state environmental divisions, unions, other industry and environmental organizations, and interestingly enough, 7 individuals have also joined the suit. And in addition, there are 6 interveners, 9 amicus curiae, and 1 movement amicus curiae. And don't ask me what the difference between those last 2 actually is. As I said, I'm not a lawyer, and that distinction is lost a little bit on me. And interestingly enough, if you read through the documents carefully, you will discover that there are 208 lawyers involved in this suit from the petitioner side. So again, the lawyers are making out like bandits on this one. So the petitioner's arguments, their core legal issues are that the rule actually violates Section 111 of the Clean Air Act in that the performance standards as proposed are not for or applied to existing fossil generation. In other words, the rule as it stands doesn't say what are the actual emission rates for an individual plant, an individual fossil fuel plant, a coal plant, or a natural gas-fired plant, or an oil-fired plant. They're saying that in aggregate, the rate needs to apply across an aggregation of generation that needs to be put together to come up with an average, where the petitioners argue that under Section 111 of the Clean Air Act, they have to propose performance standards for specific plants, specific types of plants, and not across all generation. They say that it requires the owners or operators to opt to subsidize EPA-preferred generation facilities. In other words, shift that generation to non-polluting or non-emitting sources, the renewable sources. It requires non-performance by sources instead of requiring performance standards limiting the rate of continuous emission. In other words, either shutting plants down or reducing their operations in order to shift that generation again to the other lower or non-polluting or non-emitting sources. And it also argues that the standards for existing units are more stringent than those for new units. So for the, or as quoted here directly from their arguments, for the best state-of-the-art new units. And moving on to additional core legal issues, they say they exceeded their authority under Rule 111D of the Clean Air Act because they're requiring standards of performance for sources that are already regulated under Section 112. They state that the Clean Air Act amendments of 1990, while conflicting slightly in this particular area, they choose to take the language that, to interpret the language limiting the use of the rule of 111D if it's already regulated under 112 as indicating that it requires you to only regulate a source under one part of the rule or the other, and if it's already regulated under 112, as coal plants are, given that 112 has a long list of toxic pollutants that are required to be controlled there, and that many of those are on the are emitted by coal plants in particular, that we can't have regulation under both. They also say that it abrogates the authority granted to the states because the states can't adopt a less stringent standard than the rule's national standard, that it fails to allow the states to take into consideration whatever the useful remaining life of the plants are. In other words, an economic consideration of the useful life of the plant. Okay, come on back, thank you. That it co-opts state agencies and regulators to implement the rule. And in that case, what they're saying is that because specific action is required of the state agencies or regulators in order to implement the rule, that is a violation of cooperative federalism and the way that's been interpreted in the past, in that they must take specific action in order to implement the rule. Continuing the petitioners' arguments, they had a number of procedural and record-based issues. Specifically, they say it violates Section 307 of the Clean Air Act by promulgating a rule that has never been proposed. Their argument being that because there were major revisions to the proposed rule before the final rule was issued and then published in the Federal Register, that constitutes an entirely new rule, and therefore it also needed to be available for a period of public comment before being finalized. That it violates Section 111 because it doesn't propose a best system that has been adequately demonstrated as required under Section 111. That the emissions guidelines are not achievable by the regulated sources. In other words, the emission rates as proposed cannot possibly be achieved by the coal plants that would have to reduce generation, et cetera. They are arbitrarily and capriciously exclude certain non-emitting generation from the options available to the states. Okay, a lot of this language I'm taking directly from the petitioners' arguments, by the way. And then that the EPA failed to consider important aspects of and made critical errors in the emissions guidelines. Specifically, they didn't establish necessary subcategories. They did not consider renewable energy limits. They did not regulate sources that should be regulated under 111B. They did a flawed cost-benefit analysis, and the rule is arbitrary and capricious in that it fails to accommodate individual states' circumstances. and that it caused particular harm to certain states. I'll address those a little bit when I come back around and present the counter arguments from the EPA. So this pretty much covers it's a long list of things, being very, very specific and being very, if you will, picky about specifics of specific parts of the Clean Air Act and the way the CPP rules are proposed. Now, where do the states fall in all of this? So on this map, we can see the 27 states that are actually party to the suit. We can see in solid red here, we have one state, Nevada, that opposes the rule that is, but is not actually a party to the suit. We have 3 states that are not suing. We have 1 state that is exempt. That is actually invisible on here because it's the District of Columbia, and so we can't actually see that. We have 16 states that have filed in support of the rule, and then we have 3 states that are exempt and supporting the rule. That would be, let me make sure I get this. I know Vermont and, Vermont, the District of Columbia, and Hawaii are supporting the rule. It's Alaska that's the exempt state that is not involved in either for or against the legal challenge. So this is how this all shakes out. We have a lot of disagreement going on. A little later on, I have a chart that shows how this is affecting the plans of individual states to go forward with their analysis and planning for how to comply with the CPP rule. But we'll first talk about the respondents and their arguments. Now, clearly, the U.S. Environmental Protection Agency and Gina McCarthy, the administrator, are the main respondents in this, and they're the entities being sued. In support of the respondents, we have 18 states and the District of Columbia, 34 interveners, and again, amicus curiae and movement amicus curiae. Not sure what the differences are there, but there they are. The particular arguments that the respondents, the EPA is making in particular, is that because the Supreme Court ruled in AEP versus Connecticut that the agency, the EPA, has the responsibility to regulate CO2 emissions specifically under 111D of the Section 111D of the Clean Air Act, that these rules are constitutional as they and in compliance with the law as already directed by the Supreme Court. That the petitioner's arguments involve interpretation of both the law and the relevant legal precedents that are incorrect. So they say that they have cherry-picked specific language out of the Clean Air Act and out of the legal precedents and taken them out of context, in other words, to bolster their arguments, and that when the Clean Air Act is taken and the legal precedents are taken as a whole, that incorrect interpretation is quite clear. They argue that the court, in this case the D.C. Court of Appeals, should in this case and following precedent defer to the agency's interpretation of any vague language essentially cited by the petitioners in its interpretation of the law. So how they look at it, they should in fact defer to the agency's interpretation. And in fact, that's the way the courts, particularly the U.S. Court of Appeals and the D.C. Circuit, has interpreted and ruled in previous cases that it is the duty of the agency to resolve vague or contradictory language in any law such that it is in concert with and in harmony with the overall intent of the law when taken as a whole. So, and again, previous legal precedent gives the agency the power and the duty to reconcile any possible conflicting sections of the relevant law. And again, the petitioners are cherry-picking the Clean Air Act citations that they make and taking them out of context in order to bolster their argument. and that it violates the meaning and intent of Congress as when you look at the Act when taken as a whole. So to continue with the arguments, they argue, of course, that the EPA did determine a best system for carbon dioxide emission reduction and overall carbon reduction, and that system is follows along with previous precedent whereby shifting generation from higher emitting sources to lower emitting sources has been the mainstay of the Clean Air Act throughout its history. That the administrator is the one who is charged with determining if such reductions are adequately demonstrated. So claiming that they're not adequately demonstrated is therefore a spurious argument, since that determination is specifically charged to the administrator of the EPA. And that barring the agency from regulating any source under Sections 111D that are also regulated under Section 112 would, in effect, just create legal and regulatory chaos, because multiple EPA-administered emissions programs do just that now. That these programs are not duplicative, as the pollutants regulated under 111D are not also regulated under 112. And that's where they differ with the petitioners. The petitioners say it's the sources can be regulated under one or another, not the specific emissions. Okay? The agency says the rule applies to the emissions themselves, not necessarily to the sources. Okay, and obviously they believe the claims of constitutional issues are meritless, because the rule does not coerce or commandeer states to administration or regulatory agencies to implement the rule. The states can elect to essentially do nothing and use the implementation plans that the EPA will develop, and that they are not commandeering any regulatory agencies, because the regulatory agencies already have a duty to oversee the operations of the power generation system within their states, and that the operators from within that state would have to make any major changes or bring online any additional generation to comply with this rule would have had to bring any of that online anyway, would have had to request permission from the regulatory agencies in order to get a certificate of convenience and public convenience and need, or whatever it's actually called in any individual state, and that these are normal duties of these agencies, and they're not asking them to do anything that they aren't already doing. Continuing with the arguments, this is going to be over in just this slide. They don't have 4 slides on this anymore. The revisions to the rule, as issued in its final form, were appropriate and correctly take into account all public comment on the proposed rule, and did not constitute a new rule requiring another period of public comment. So that, therefore, the petitioners have not shown that there was any substantial likelihood that any different procedure, in other words, reissuing the rule as a proposed rule and having another period of public comment, would have yielded any significant change to the rule. They didn't raise these procedural challenges during the public comment period between the initial issuing to the initial rule and the final rule. And that EPA, in fact, did identify an achievable best system, primarily through the use of generation shifting from the higher emitting sources to lower emitting sources, admittedly, but that is the system that they came up with. That they did account for geographic considerations, that renewable generation projections were conservative and based on historical patterns. The petitioners actually argued that the EPA didn't use sufficiently conservative estimates of renewable generation potential, to which the EPA has responded that they did use, because they used NREL, the National Renewable Energy Laboratory estimates, which are considered quite conservative in terms of the overall potential. So that was their counter-argument to the petitioners' arguments, that they didn't consider impacts to Wyoming and Utah, specifically coal-producing states, and that concerns regarding tribal lands in Utah and Arizona are speculative at best, largely because the state implementation plans have yet to be developed and released, so that there's no way to show one way or the other whether any harm would occur to those tribal lands. So that's our arguments. And now I'll talk about what I think might actually happen at the U.S. Court of Appeals for the D.C. Circuit. They have historically shown deference to federal agencies' interpretation of federal law. That's the precedent that has been referred to several times in earlier slides. Therefore, I believe they are likely to deny the petition to vacate the rule. That's a personal opinion, obviously. So regardless of the decision, this will be appealed to the Supreme Court. And as I said, with the Court of Appeals hearing the case at the end of September, the likelihood that we will get a decision, certainly not before the Thanksgiving, but before the end of the year, is probably iffy at best. Early in next year is probably a little more likely. But regardless of what happens, it's going to be appealed to the Supreme Court. So how does this impact overall state planning? So here we have another nice E&E's Power Plan Hub map that shows that 20 states have suspended their planning altogether to prepare for the Clean Power Plan. 19 states are continuing planning. Notice that some of those are parties to the suit. We have 8 additional states that are assessing whether they're planning, have to do any planning or not. And of course, we have 4 states, Vermont, Alaska, Hawaii, and the District of Columbia, counting the District of Columbia as a state for these purposes, are exempt because they don't contain any coal power plants at all. Those 4 zones, states in the District of Columbia do not have any coal plants, so they're exempt from the rule to begin with. So we have a large portion of the country containing a large amount of the coal generation that is not proceeding with any planning for to determine whether they're going to comply with how to comply with the CPP and issue a state implementation plan. So this contributes to my assessment that this is a mess at this point. So I have a couple of slides on some reference case results, and then I'll wrap this up with some conclusions, and then we'll see if we have any actual questions for you all to direct my way. So from our fall reference case, we note that there are CO2 emissions prices here, and I will point out in particular the CPP implied emissions prices. That would be this line running through the middle here, and that becomes significantly higher than the regional greenhouse gas initiative prices that we were expecting to see. And again, while not significantly higher out into the early 2030s, does become significantly higher as you go out over time relative to a CO2 tax that would have flatlined at about $20. This is, again, results that we have from our different scenarios under the in our reference case, looking both with and without the Clean Air Act in place, the Clean Power Plan in place, excuse me. From our fall reference case, again, we see that the all hours scenario power prices under these different conditions show that the EPA's, under EPA CPP, our overall all hours average power price in dollars per megawatt hour is actually lower than it is in our low gas price, but is a little bit higher than our, a little bit lower than our base price, and is only higher than the low gas price case that we have. Our high gas price case obviously significantly higher, and with a CO2 tax it is actually higher than it would be either in the base case or in the CPP case. Now, this is not an all-in price and does not include the fixed cost, recovery of capital costs, et cetera. This is just the actual raw energy price, so it doesn't necessarily tell us that overall prices would be lower. It's just saying that what would the energy-only price in the markets be for those time periods. If we look at our spring reference case results across the all-hours scenario price, in the spring reference case, because the Clean Power Plan has been put on hold, we didn't do a specific Clean Power Plan scenario. What we did, however, do was run a high renewables scenario, and we can see even with very high renewables in that case, that the base case and the high renewables case energy price for all hours, average across all hours, stays fairly close together out to the end of our time frame, 2040. So we don't expect there to be a tremendous impact on the power price per se. It may affect our capacity prices and certainly may affect specific hours, but again, this is an all-in across all hours average power price. So in conclusion, again, I guess I should have warned you at the beginning, I did not expect this to take an entire hour, but we will be wrapping up shortly. In conclusion, the U.S. Court of Appeals for the D.C. Circuit, I believe, is likely to deny the petition to vacate the rule, as I stated earlier. So they will deny that, I believe they will deny that petition. The ruling is going to occur late this year or very early in 2017, and then it's going to get appealed to the Supreme Court. Now, in case number one, we have the Supreme Court hears the case, but Justice Scalia has not been replaced when that appeal is heard, so that we are likely to get a split decision on any from the court on this case. I come to that conclusion by looking at the justices that are still on the court that voted for the stay of the rule pending the result of all the court cases versus those that opposed the stay. And since that's an even 4-4 split, I would expect them to vote the same way, to rule the same way going forward on the appeal. So the lower court decision, whatever the U.S. Court of Appeals decides, is likely to stand. Okay, and it'll be another 6 months after the D.C. Court releases its ruling before we're going to have all of this play out, and that's at least another 6 months before we have a ruling from the Supreme Court. Therefore, barring any additional delay in these proceedings, the rule is ultimately going to go forward, but the timelines will need to be adjusted. Okay, now I have case number two. And this, before the Supreme Court, where the Supreme Court decides to take the case, but Justice Scalia has been replaced when the appeal has been heard. So then it's going to come down to whatever happens in the presidential elections in November. Whoever wins gets to nominate the replacement for Justice Scalia. So all bets are off now. We don't know what's going to happen, and so it depends on what you think is going to happen in the November elections, and at this point, I'm not going to make a call on that one. So, but it's still going to be, regardless, another 6 months before it all plays out after the appeals court decision. So that's my presentation, and I guess I need to somehow figure out if I have questions floating around out there. Are they coming through the chat, Dana, or are they coming through in a different manner?
If you do have questions, you can submit them either through the chat or through the Q&A window in your WebEx screen. It's on the right-hand menu panel there. And currently, I don't have any questions from anyone yet.
All righty. We'll pause momentarily to see if anybody wants to send me a question, but if there are no questions in the next minute or so, I will thank you for your attention today, and I hope you learned a little something today. It was quite an experience for me to wade through all of the filings by both the petitioners and the respondents in this case, particularly since, as I said, I'm not a lawyer, so it was a lot of fun reading some of this stuff.
We do have a couple of questions coming in. Let me just
yeah, I'm not seeing those right now since I took over and I'm showing it on my screen. So
just a moment. Okay. Do you think it's possible for a Supreme Court justice to be appointed before the November election?
Well, the Supreme Court justice has been appointed before the November election. I just don't think the Senate is going to even bother holding hearings in committee or bring that to a vote on the Senate floor prior to the election. I don't think we're going to see a new Supreme Court justice before until the new president is inaugurated in January.
Next question, if the timeline needs to be adjusted, are opponents buying time here?
That's entirely possible, yeah. They may just be buying time, but I think with the amount of money that they're spending just on the case, I believe they do think they have serious argument for vacation, for avoiding the rule altogether, or vacating it as the legal term would be. But certainly they've bought time. How much time? Certainly not more than 1.5 to 2 years.
Next question. Who are these individuals on the petitioner's side?
Oh, geez. Who are they? I'd have to go hunt through the paperwork and find where their names are listed in the bottom. But it was, as I said, it was just a few specific individuals that were named as individuals, as opposed to being representatives of an organization. So I'm not sure. Reply brief. I've got all the paperwork here in front of me. I'm kind of shuffling quickly to see if I can find it. That's the respondent's initial brief. It's the opening brief of the petitioners. Let's see if I can find them. They were down here at the end. Give me a minute. These are thick documents, by the way, so this is not a quick question to answer. Do we have another question while I'm attempting to take a quick look for this?
Yes, we do. What non-emitting sources, and that's in quotes, are the petitioners talking about that the EPA is not taking into consideration?
They were not specifically existing, existing nuclear plants and some existing hydro plants, particularly large hydro plants.
And we do have another question when you're ready.
I'm still looking here. I think these are the councils of record. I tell you, these are long documents, very long documents. I'm having trouble finding that where the listing was. I just remember when I went through this originally, I was able to pull out the names of all the specific agencies and organizations. And I'm sorry I'm not finding it right away, but is there another question at this point?
Yes, there is. Most of the recently released CPP models are showing significantly lower predicted CO2 allowance, ERC prices, than you showed. Can you explain what might account for the differences?
These were modeled as specifically as if it was a CO2 tax, as opposed to the ERCs as actually outlined in the rule. So the modeling is a little bit different. So I think that accounts for the differences. That the treatment of how we treated it and how we actually do the calculation may be a little bit different than those models. So anytime you have a difference in model from different groups and how they've done the underlying assumptions, you are going to see differences. So I'm sure it's the model differences and assumption differences that are primarily contributing to that.
Here's a question from the same person. the base case and CPP case show similar marginal energy prices.
Mm-hmm.
What technology and fuel are at the margin?
Most of the time it's going to be gas, and it's most of the time, since it's average across all the hours, a lot of the hours it's going to be gas combined cycle, natural gas fired combined cycle.
And that's all the questions we have at this time.
Okay. Well then, I appreciate your time and your attention, and particularly your questions. And again, as I said before, I hope that I was able to bring some new information, or at least wrap enough around the totality of the arguments in the court case to give you a better appreciation of what's entailed there. So I appreciate your attention, and thank you very much today.